5 seconds to go. Start. On the basis of the evidence led, the learned single bench decreed the suit. However, the first appeal was accepted inter alia on the ground that the appellant has failed to prove that it was registered as a dealer with the sales tax authorities in Delhi, and it failed to prove having any go down in Delhi. Since the appellant has failed to prove that it was a registered dealer, it could not effect any sale of paper at Delhi without paying central sales tax. The division bench of the High Court held as under. Learned counsel for the appellant argued that the finding of the High Court is patently erroneous, as the respondents have not denied that the appellant is a dealer in the state of Delhi, which is evident from para 10 of the written statement reproduced above. It was further pointed out that the respondents have not disputed the registration of the appellant in the written statement, nor any issue was framed about the appellant being a registered dealer in Delhi. Therefore, the High Court had made out a new case for the respondents when such case was not even referred to in the written statement filed. The appellant had filed a registration certificate as the reseller dealer in Delhi as Annexure P12 along with an application to produce such certificate. The said certificate shows that the appellant was registered as a dealer under section 14 of the Delhi Sales Tax Act 1975. The nature of business being reselling of paper and boards only. There is a mention of go down in the registration certificate as well. Learned counsel for the respondents supported the judgment of the learned division bench and relied upon judgment of this court reported as Subra Mukherjee and another versus Bharat Cooking Coal Limited and others to contend that the onus of proof whether transactions were genuine and bona fide has to be discharged by the appellant. Learned counsel for the respondents also relied upon the judgment of this court reported as Ishwar Das Jain versus Sohan Lal to contend that the appellant has not produced account books but only extracts which are not admissible in evidence, and hence suit was rightly dismissed by the High Court in appeal. We have heard learned counsel for the parties and find that the division bench of the High Court has gravely erred in law in accepting the appeal of the respondents on wholly erroneous and untenable grounds. Each of the invoices produced bears the registration and also bears the stamp and signatures of the managing director, director of the respondents. Apart from such invoice, the appellant has proved the debit note, which has also been stamped and signed by the managing director. The ST1 form also bears the stamp and signature of the director of the respondents. Stop.